Welcome, everybody. I am happy to be here, and I'll be serving as your moderator for this what promises to be a very rich and excellent program on the crisis in Ukraine and the conflict that's currently playing out between Russia and Ukraine, and that's drawing in many other countries through actions that you will hear about here. If not military actions, nonetheless, some that are considered by some parties to be tantamount to acts of war. So I'll introduce everybody first, and I'll just introduce myself first. My name is Michael Strauss. I'm a professor at the Centre d'études diplomatiques et stratégiques in Paris, where I teach international law and international relations. And to my left, your right, is Cara Radelli, who you probably all know. You're all from here, no? Yeah. From the Geneva Academy. And to her left is Elena Duan, the special rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. And on her left is Professor Marco Roschini, who is a professor of international law at Westminster University in London, which is where Professor Duan and I met in a conference on Guantanamo in January of 2010, which turned out to lead to a lot of collaboration since then. Well, as you can see. Anyway, why don't we start with Professor Duan, the special rapporteur, and she will be speaking about the sanctions issue that's part of this, that is becoming a big part of this conflict and causing probably every country in one way or another to become involved either directly or indirectly. But I'll let her say all that. Okay, Elena, the floor is yours.
Thank you very much, Michael. First of all, I would like to thank the Geneva Academy for organization of this event, because I believe that we all hear in the media enormously a lot about the conflict which takes place in the Ukraine right now, but we hear only about the new sanctions being imposed and proposed to be imposed or tightened or strengthened, without any assessment as concerned, any evaluation as concerned the issues of the illegality or as concerned the issues of the humanitarian impact. And sometimes even I, being the special rapporteur already for 2 years, have a feeling as if all this information comes in vacuum and has never been analyzed. And that's why I believe that this discussion is very timely, is very important to understand the possible consequences and possible risks which arise because of so rapid implementation of the enormous amount of sanctions unilaterally against Russia, Belarus, and third threats to impose sanctions against third country companies and third countries for possible circumvention of sanctions regime or cooperation with companies or individuals which are currently sanctioned. I just need to make a small remark that as a special rapporteur, I will speak about sanctions only, not going beyond that. That are the rules. So what's happening today? Today, when we speak about the situation and sanctions imposed against Russia and against Belarus as concerned the conflict in the Ukraine, we have figures. So that's basically what we're facing today is a pretty unique case when an enormous amount of them have been imposed rapidly without huge assessment and without assessment of the legal and humanitarian risks and perspectives. Take into account that they have been imposed very recently, it's very difficult for me to provide the exact figures of the impact. Therefore, I can only speak about the risks which I observe from the consequences of sanctions being imposed over other countries, like, for example, Iran, Venezuela, Zimbabwe, Qatar, and many other. So, moreover, taking into account that the scope of sanctions imposed is enormously broad, if I will start to speak about the legal assessment of every single one of them, our discussion will last probably until the weekend. So therefore, I will just speak about the risks and the international law questions which shall be addressed when we discuss the imposition of sanctions. And I hope that international lawyers will be addressing every single of that issues, and they will be taken into consideration for any future steps. So I will start with the point, what do we have today as concerns the scope of sanctions imposed? And the scope of sanctions imposed is very broad in reality. So first of all, the reserves of Central Bank of Russian Federation in the countries which impose sanctions are frozen, and the amount which is currently announced is really huge. They speak about $300 billion of the reserves. So that's a lot for every country. Then a number of Russian and Belarusian banks have been cut off of the SWIFT. Thirdly, the reserves of nationals of Russia and Belarus abroad have been frozen. And we are speaking about various types of reserves and estates. You may quite often see in the news the frozen reserves and frozen some sort of property of Russian oligarchs. But in reality, if one looks in details, for example, on the decisions of the European Union, the recent decision requested banks to freeze all reserves which are higher than $100,000. So that's not about enormous oligarch amounts. Then travel bans are imposed. As a result of that, Russian airplanes are not allowed to fly to Europe and many other countries. The leases are supposed to be stopped. The same concerns Belarusian air company, and moreover, the flights of European, United States, and many other companies' airplanes are also not allowed to the territory of both Russia and Belarus. Naturally, there is also an element of the security of civil aviation, which provides for the need to provide guarantee that the plane won't be shot when flying above the territory of the conflict. So it adds extra complicity to the situation. Then, coming further, serious sectoral sanctions have been imposed over a number of sectors of industry, both in Russia and in Belarus. That's oil sector partially, the sector of woods, the sector of fertilizers, mining sector, and many others. Then the issue of both the United States and the European Union have prohibited transfer of banknotes of dollars and the euro, both in Russia and in Belarus. That basically means that these paper money are not available any longer in the country. All companies are called to stop cooperation with Russian companies and with Belarusian companies. And as you see, quite often it's reported that certain businesses are withdrawing. Besides that, I believe it was yesterday's decision by Biden administration, the United States have prohibited the import, both in Russia and in Belarus, of so-called luxury goods, which include 520 types of items, including cosmetics and watches and many other elements. Besides that, when we speak about sanctions imposed, we speak about the cutting of access for different sorts of Russian and Belarusian media in Europe or in other countries which impose sanctions. We speak about the decision of sanctioning states to stop development or engaging in any research projects or opening any research grant lines. And moreover, recently there was a decision by a number of the publishing houses which changed the publishing policy and requesting to use extra caution when deciding on publication of articles prepared by scholars from countries under sanctions. There are some, as a result, so that's a general overview. I do not go in details to some other technicalities, but as you see in general, the scope of sanctions imposed is very, very broad. When one speaks about the policy of the Office of the High Commissioner of Human Rights and my mandate, the Human Rights Council has repeatedly addressed the issue of application of unilateral sanctions since a pretty long period of time, and within the last 10 years, the problem turned to be so sensitive that the mandate of Special Rapporteur has been established in 2015. I'm the second Special Rapporteur, and unfortunately, what we face today, we have an expanding amount of sanctions, and no one knows what we're talking about because there is no universal definition what unilateral coercive measures are. Moreover, we have new terms being invented every month. Restrictive measures, preventive measures, secondary sanctions, primary sanctions, targeted sanctions, individual sanctions. Well, the list is very long. Moreover, there is a very little willingness for discussion. If one checks every single resolution of the Human Rights Council on that regard, it will be clearly seen that 2/3 are in favor of resolutions and 1/3 which imposes sanctions is against resolution, and we face no dialogue. That's why the issue becomes terribly politicized. However, when we speak about the legal document, a number of resolutions of the UN Security Council, as well as a number of resolutions of the UN General Assembly, announced the use of unilateral coercive measures to be illegal. From the point of legality, if we do not know what the unilateral coercive measures are, it's very complicated to identify what is illegal. Point number 2, the problem is that the scope of terminology is so broad that every single type of unilateral sanctions imposed is usually pretended to be imposed in good faith for common goods and not constituting unilateral coercive measures, being something different. And that's why the legal analysis is so important on that regard. When we speak about every specific type of sanctions, we need to qualify how we see this issue from the point of international law. And therefore, if the issue is not legal, as lawyers, we understand that it shouldn't be applied. So I'm referring to the basics of international law. We all know that the Charter of the United Nations provides for the possibility for the UN Security Council to decide on enforcement measures. So if measures are imposed by the UN Security Council, no one doubts the illegality. And that's not the case in this specific situation. What else shall we check from the point of international law? We all are aware about the existence of countermeasures mechanism under the draft articles on responsibility of states. And the unilateral sanctions are often cited as a mechanism of countermeasures, but unfortunately not all elements necessary to qualify countermeasures are taken into account. I speak about necessity, proportionality to injury caused, purpose is to stop violation, and prohibition to violate fundamental human rights. Naturally, we all are aware about the possibility of retortions and friendly acts which do not violate international obligations, but again, when we speak about retortions, these measures shouldn't violate international obligations, including in the sphere of human rights. So that's basically the framework we need to use when assessing every specific type of unilateral sanctions imposed. But besides that, we need to take into account some other considerations. The very first one concerns the immunities. And I speak about the judicial immunities of state property, including the judicial immunity of assets of central banks, as it's provided in the Convention of 2004 on judicial immunities of states and their property. I speak about the immunities of higher state officials, as elaborated a lot in the work of the International Court of Justice, and I would speak about the arrest warrant case. as well as the relevant practice. Moreover, I speak about the principle of peaceful settlement of international disputes, which basically requests states to negotiate in good faith and do all possible to find a peaceful solution of the dispute. And here we come to a very relevant question. Is the application of sanctions a good faith cooperation step to find a peaceful solution of the international disputes? Then I speak about the presumption of innocence. As soon as we come to targeting of specific individuals, saying that they are bad guys, that's usually done. The question is the following, which I want to ask is the following. If a person is considered to commit a crime, the person shall face a criminal procedure and shall be accused in committing the crime. And if he or she will be found guilty, he or she shall face the consequences. But announcing a person to be a bad guy without the due process violates the right to due process, violates presumption of innocence, and if the person has really committed a crime, it keeps him impune or her impune, because there will be no court verdict. And that's another problem. Then I speak about the issues of extraterritoriality. There are a number of documents referring to the illegality of extraterritorial action, and I would cite here, for example, the European Union Blocking Statute and the position the European Union has repeatedly expressed that extraterritoriality is illegal when one speaks about any action taken by states or regional organizations. Second, at the next point, I would refer to the issue of the access to justice. If someone is facing some sort of his rights or her rights to be violated, the access of justice shall be guaranteed. But for example, in my practice, I'm quite often facing reports that companies or individuals face serious problem to apply for protection of their rights, even in commercial arbitration, because they can't transfer money as the bank transfers are blocked. So they have no availability for these legal means. Moreover, mechanism of to access justice as concerns individual sanctions are not so easy. They are easier within the European Union, within the work of the European Court of Justice, but they are extremely complicated as concerns sanctions of the United States, for example, as well as of many other states. So access of justice is also a problem. The next question which we need to take into account when we speak about legality are the threats with secondary sanctions. And here we come to the interplay of extraterritoriality and the legality of threats. So third country nationals are threatened to face civil or criminal penalties or be also designated for cooperating with individuals and companies being already sanctioned. That basically means that it results in overcompliance. Everyone is scared. The fines which have been imposed, for example, as concern the Venezuela banks, or fines the banks which cooperated with Venezuela, there was a French bank, and a number of others, speak about $9 billion fines, $5 billion fines, which is unbearable for any organization. So I have noted several legality issues, but in reality, there are much more of them. And if there will be any questions, I can elaborate on that a lot. And now I would like to speak about the possible risks for the population. As I said again, the duration of time is not so high. That's why I can only refer to something what has already happened and the risk which I see as concerns other countries. When the sectors of economy or specific companies are designated and are cut off the trade, it results that they can't get the revenue any longer. If the sector of economy or a company doesn't get any revenue, it basically means it needs to find a way how to cut off expenses. That means that people are losing their jobs. People have no other sources of income. Their families are affected and people are affected as well. But beside that, unfortunately, we forget about trade partners, families of trade partners. For example, the very first reference after the first round of sanctions imposed against Russia, I received a message from Ecuador. saying that we are producing flowers to be delivered to Russia, and it was a few days before the 8th of March, Women's Day at the post-Soviet territory. So lots of flowers are sold, and flowers are delivered via air companies. As far as no flights were allowed any longer, all the flowers which have been produced in Ecuador and were supposed to be delivered to Russia and to Belarus, all that was in vain. So serious losses for the producers and serious losses for their businesses and for their property rights as well. Beside that, I'm speaking about trade partners, about people who depend on export and imports far, far away. I will give another example of fertilizers. Both, for example, Belarus and Russia are producing potash fertilizers, and their joint production constitutes 40% of the world market. Today, the Food and Agriculture Organization is reporting about 800 million people being food insecure worldwide. If the countries, like African countries or countries in Latin America, which depend on that fertilizers, won't get them at the appropriate price, and the price is getting higher as far as transportation and logistics links are cut off, if they won't get it, and there is no replacement, because you can't just get fertilizers, you need to extract it in the proper way. Two more times people may become food insecure. So lots of people are endangered, being somewhere far, far away from the conflict and far, far away from the countries which are designated. Besides trade partners, beside the families, beside the export-imports company, beside the transportation companies, the whole population of the country is traditionally affected. If you can't get foreign currency, that means you face terrible inflation. Your salary stayed the same. May I ask for 3 more minutes?
All right. But this is not necessarily a precedent.
Okay. Your salary stayed the same, and you face a terrible inflation. I will cite, so far in Russia and Belarus, the inflation comes up. So salaries are losing the purchasing value. No one knows what will be the end point. But for example, in Venezuela, under sanctions, there were years when inflation was 1,300,000% per year. So people's salary was just a paper. Paper was more expensive than the salary they received. Yes, it's a problem to buy the paper in Venezuela because of all that. That basically means that the income of the whole population is much worse, and their rights are violated because they need to feed their families, to buy clothes, to take care of education and many other. And unfortunately, those who are the most vulnerable are affected the most. If you already had low salary, your salary becomes absolutely nothing. And I'm speaking about those, for example, about orphans. I speak about people suffering because of the chronic or serious diseases, because their income is low, and it depends on the social protection from the side of the government, and it depends on medicine. So far, for example, I haven't heard reports about the rejection of foreign companies to provide pharmacy to Russia and Belarus. Not so far. But in many countries, it's a problem. It's a problem in Iran, it's a problem in Venezuela, it's a problem in Zimbabwe. I submitted several communications to the producers which reject to sell medical goods. And for example, the decisions about imposition of sanctions on Russia and Belarus, they do not contain humanitarian exceptions clauses at all. Although in reality, the existence of humanitarian exceptions clauses doesn't guarantee that the goods like medical goods will be delivered or the food will be delivered. So potentially, that's a serious problem, especially for the most vulnerable groups of population, those who need medicine. And unfortunately, in many countries, it ends up in the simplest disease, like, for example, angina. We need basic antibiotics to treat it, but they are not available. Or something else like insulin in Iran, there are lots of diabeticals all around the world. It's not available any longer. So that's another problem. Another problem is the rejection of the company to trade with countries under sanctions, as is happening today, as concerns Russia and Belarus. I would refer, for example, to a recent statement of IATA concerning the rejection of foreign companies to provide and sell spare parts for airplanes to Russia. And IATA was very explicit about that. It said that we are very much concerned because the absence of spare parts undermines the security of civil aviation. So we endanger the rights of people. The same comes to traveling. The freedom of movement is limited enormously. I can say I'm a Belarusian national. I was traveling from Minsk. It used to be 3 hours. Now it shall be around 20 hours to get to Geneva instead of 3. And naturally take into account that if you fly longer, the emissions of planes is higher, you affect the environment longer, it takes money, it takes time, and so forth. The same refers to media, for example. If you do not have access to information, you can't verify the facts. There are always several positions. You need to be able to reach out the media, to have freedom of expression, to have freedom of access of information, to be able to understand what's going on. The same exists in the research sphere. People are losing the possibility to be published in journals in Europe or in the United States not because the quality of their research is bad, but because they come from the country under sanctions. And I have already received several reports from Russia and from Belarus that the articles were just rejected without any explanations. The same comes as concern the possibility to start new research projects. There have been lots of statements in the media when the research institutions in the countries, sanctioning countries, say, no, we won't continue any longer. The most ridiculous case, which I unfortunately just proves what I saw in many other countries, when the ONCA research institution in Europe, which used to cooperate with the Russian one, said that as a protest against what was happening, they stopped cooperation. Who is targeted in that case? Just cancer children, which, as I saw in the case in Venezuela, are dying because of something happening like that. I have been shown this paper that my time is over already for 5 times, so I stop here. We'll be happy to answer any questions.
Okay, thank you, Professor Duan. And we will have time for questions after all of the speakers. So why don't we move on to our second speaker, which will be Professor Roshini from Westminster University.
Thank you very much. And thanks to the Academy for inviting me. I have to say that it feels slightly awkward to be talking about technicalities, legal technicalities, but people are being bombed as we speak, or people are living under strict sanctions. But I guess that's our job. And in the hope that even legal technicalities can help solve this crisis. But after all, the Ukraine itself has started several legal claims before international tribunals, so that's part of the situation, and that's also part of the solution, hopefully. So I'm going to address a few points about the use of bellum and use contra bellum issues arising from the current crisis. I'm just going to briefly address Russia's justification for the invasion, as delineated in Putin's speech of the 23rd of February, because, well, they are well known. I'm sure a lot has been already said about them, and to be honest, they're not particularly sophisticated, so they don't really require a long rebuttal. But just to summarize what I think the essence of Putin's speech is about the Russian invasion, he basically bases the invasion on the right of self-defense. It is actually expressly mentioned, the right of self-defense in Article 51 of the Charter. It's not entirely clear whether he refers to individual self-defense, collective self-defense, or both. In any case, individual self-defense is clearly not applicable in this case because there's no armed attack, not even an imminent one. At best, there could be an attack in the future from Ukraine should Ukraine become a member of NATO. It could be that, as Putin says, the conflict will spread to Crimea, but all this is really what we call preemptive self-defense, which has no basis in the chapter. It's basically the Bush doctrine that mocks us from the grave. It's not collective self-defense, because collective self-defense exists when the victim of an attack is a state. And the People's Republics of Donetsk and Luhansk are not states, in spite of their recognition by Russia. And if they're not states, it's not collective self-defense. It is an armed intervention with the invitation of insurrectional authorities. Which is a violation of international law, as the ICJ clearly said in the Nicaragua judgment. It's not humanitarian intervention, although humanitarian intervention does not seem to be used as a proper legal justification in Putin's speech. Seems to be more the motive, the purpose of the intervention. As I said, he seems to be technically relying on self-defense only. But humanitarian considerations are certainly mentioned as context. But again, we all know that, I guess, probably most of us will agree that the right of humanitarian intervention is quite controversial, and it's an understatement in international law. It's unlikely to be law, and there's nothing in the Genocide Convention that suggests that the use of force is the right way to enforce it. Therefore, I would discard this justification as well. Not to mention the fact that there is no evidence that actually acts that could qualify as genocide are being committed by Ukraine. And just to remind you that the ICJ itself, as the case now will be heard by the ICJ, that the ICJ's case law has, I'm thinking of the Bosnian genocide case here, expects the parties to prove the commission of acts of genocide with fully conclusive evidence, which seems to be a higher standard than clear and convincing evidence, which is the standard normally referred to by the court in cases of state responsibility, including violations of the use of force. When it comes to the commission of crimes under international, again, the more serious the violation, the higher the standard of proof required. So that's what Russia would have to prove to provide fully conclusive evidence that genocide is being committed. But anyway, so that's me done with Putin's speech. What I would like to say, and I'm saying something that I guess is controversial, as I think I've been probably the only one that said, well, I actually published this view in a blog post a couple of weeks ago. My view is that we don't even need to look into these justifications, plausible or implausible as they might be, because the violation of the use of force by Russia was actually committed in 2014 and not in 2022. In 2014, Russia occupied Crimea. And is still occupying it. And if you look at the definition of aggression that was drafted by the General Assembly of the United Nations in 1974, the occupation and or annexation of another state's territory, whole or in part, is an act of aggression. The use of forces, the armed forces stationed in another country, beyond the consent of the host country, is an act of aggression. Think of the support by Russia of the separatists in the Donbass region, again since 2014, which it seems it has taken several forms, the supply of heavy weapons, but also apparently with proper forces, covert military units or so-called volunteers. Again, sending regular or irregular forces in another state to commit acts amounting to the use of force is an act of aggression according to the definition of aggression. So, in my view, I mean, it's a quite basic logical syllogism. Occupation has started in 2014. Occupation is a use of force. The use of force started in 2014, and you could say the same about the support of the separatists by Russia in 2014. Why am I making this point? I'm making this point because even if, and that's a huge if, Russia had any valid justifications for the invasion in 2022, the use of force by Russia would remain illegal. It would remain illegal because it's simply the continuation and the escalation of a use of force, unlawful use of force, that started in 2014. Obviously, in this case, Russia's justifications are not that convincing, but in similar cases, the situation might be different, and therefore, I think it is important to establish exactly when the use of force starts and when it ends for the qualification. Because once I'm borrowing Judge Beramantri's words here in the Nuclear Weapons Advisory Opinion, and paraphrasing them, but the jus ad bellum door had been opened in 2014. And Russia had entered the door in 2014. Once an armed conflict has started, what we need to look at is who started it. But then every single individual military operations within that use of force is assessed under the jus in bello, not ad bellum. This is not to say at all that the jus ad bellum is no longer relevant. But in my view, it's not relevant to assess the illegality of Russia's invasion in 2022. In my view, it is relevant to assess the reaction, Ukraine's reaction, from 2 points of view. First of all, it wasn't entirely uncontroversial that Ukraine could exercise its right of self-defense before 2022. I'm not going into the merits of this, but the occupation was virtually unopposed. The occupation had also been going on for some time, so some have said that in cases of frozen conflicts, the state, the territory which has been occupied, does no longer have the resort to self-defense to retake it. In the Donbas region, it hasn't been, I guess, proved fully whether Russia has really sent military units, whether their conduct is attributable to Russia. Also, sending arms is a use of force, but it's not an armed attack, according to the ICJ. So there could have been debate on whether Ukraine could have reacted by force in self-defense before Russia's invasion. Obviously, this point is now purely academic, as nobody would doubt that since the 24th of February, there is an attack by Russia against Ukraine, and that Ukraine is exercising its right of self-defense, and other states could, if the political will is there, exercise the right of collective self-defense in its support. I'm not saying that that's what they should do. I'm just pointing out what the legal situation is. How are we doing with time? Okay. Right. Another point that I would like to, actually this is important. The second relevance of the jus ad bellum in this context is the fact that invasion serves as the measure of the legality of the reaction. Okay, so not only it grounds the reaction without any, I guess, reasonable doubt, but it also measures the legality of Ukraine's and potentially other states' reactions. A reaction in self-defense is triggered not only by the occurrence of an armed attack, but also by the necessity and proportionality of the reaction, which means that it is a continuing assessment. It doesn't stop at the first shot, but it continues for as long as the armed attack and the reaction to it continues. So the invasion of Russia, as I said, is the measure to calculate the necessity and proportionality of any reaction in self-defense by Ukraine and other states. I should also add the fact that there's also perhaps a third relevance of the use of bellum in this context, the fact that any agreement that might be concluded between Ukraine and Russia, we know that there are ongoing negotiations. Some agreement might come out of them, perhaps an agreement about the territorial status of some parts of Ukraine. Ukraine might recognize the transfer of the sovereignty of Russia over Crimea, perhaps of the Donbas region in whole or in part. Well, I don't think those agreements would be valid. Of course, the invalidity would have to be invoked, but as such, I think those agreements would be a textbook example of treaties invalid because of coercion, right? That's what the Vienna Convention on the Law Treaties says. The treaties that are the result of the threat or use of force in violation of the Charter are invalid because of coercion. Anyways, how long do I have?
About 5-6 minutes.
5 minutes. Right. As I want to leave enough time for the Q&A, as I'm sure this is really one of those cases where the Q&As are more important than the presentations themselves. I'll just address this point. Because I've seen it in the many blog posts that have been written in the last couple of weeks. Does the law of neutrality prevent other states from supplying weapons to Ukraine? Some say no, it doesn't. Some say yes, it is, but it is qualified neutrality, which has been done by the United States during World War II. Others say that there's no such thing as qualified neutrality, and so on and so forth. I think that we are mixing different layers here. So the supply of weapons to Ukraine can be assessed from several points of view, from several regimes of international law. One is the jus in bello, and I think Chiara is going to address it. So, for instance, whether the supply of weapons to Ukraine is something that makes the supplying state a co-belligerent. Again, I'm not going to touch upon this point because that's relevant for the jus in bello. But that supply of weapons, however, can also be assessed, also falls under the scope of the jus ad bellum and the law of neutrality. From a jus ad bellum point of view, the supply of weapons to Ukraine by, say, France is lawful. Okay, we could discuss whether it is a collective self-defense measure or whether it is a countermeasure. But I guess, especially as a collective self-defense measure, I think that's hard to say that it wouldn't be lawful. It looks, like the collective self-defense, or as I said, a countermeasure, if you believe in collective countermeasures adopted by states in support of an injured state / the state victim of an armed attack. From a law of neutrality perspective, on the other hand, the supply of weapons by a non-belligerent state to a belligerent state is no neutral act, which results in the loss of the neutrality benefits. Okay, it's the law of neutrality is an exchange of benefits. I stay out of the conflict, and you keep me out of the conflict. If I'm not staying out of the conflict, then you are entitled to treat me as a belligerent. So the supply, again, I don't think it's correct to say that supplying weapons is unlawful under the law of neutrality. You simply lose the benefits that arise from that. Russia, under the law of neutrality, would be entitled to prevent that supply of weapons. But again, we go back to the jus ad bellum. If it does so, say if it attacks a ship of a third state carrying weapons to Ukraine, they would breach the jus ad bellum for two reasons. First, because they're already responsible for a violation of the jus ad bellum. So they're allegedly, reasonably, I think, in my view, the aggressor state. So any act against Ukraine or other states that is part of the use of force falls under the same illegality. Second, the supply of weapons by, say, France to Ukraine is a use of force, but again, I'll refer you back to the Nicaragua judgment, is, according to the court, never an armed attack. So you could not say that France is conducting an armed attack against Russia, that Russia can respond to by invoking self-defense. Anything less than armed attack, Russia could respond only with measures short of the use of force, therefore not by sinking a ship carrying any type of weapons, for that matter. But I think I'll stop here. I prevented you.
Okay, thank you very much, Professor Rossini. It was very enlightening. We are already starting to get a couple of questions in on the chat, and they're very good questions, and I want to encourage others to ask as well. So please send in any questions you may have, and we'll hopefully have time for those at the end. In the meantime, and obviously we'll have questions from in the room as well. I mean, you did show up, you have the right to ask questions. So why don't we move on quickly to Chiara Radele, who will talk about the IHL aspects.
Thank you. I'll just share this screen because
you want to switch
maybe
places?
you can. Thank you, Tatiana.
Okay.
And I take these.
Yes.
I have a couple of slides, but mainly because just to keep in mind the law and the Geneva Conventions and the additional protocols that are the articles that are relevant for IHL challenges that are raising now in the situation in Ukraine. Now, to be honest, like to talk about IHL in Ukraine right now, we could have an IHL course on that. So obviously that's not what I'm going to do in 20 minutes. However, I do want to raise a few issues and to address some controversial aspects of challenges related to IHL in Ukraine. And I want to start with the classification of the conflicts, also drawing upon what Marco just said. Marco was talking about the involvement of third parties in the conflict and whether it's a violation of the laws regulating the use of force between states, while I will do it from an IHL perspective. Now, and just to clarify, and I also would like to thank Marco for mentioning it already. Now, this is not a new war, and sometimes we read in the news and it seems as if the war started a couple of weeks ago. This is not true. There was already an international armed conflict between Russia and Ukraine since 2014. Since 2014, there has been also, and you see it in the map, which is from the New York Times, tracking a bit what's happening right now on the ground. But there has been also a non-international armed conflict in the eastern parts of Ukraine that now have been recognized as independent by Russia, but it still remains a non-international armed conflict. And Russia has been involved into this conflict. However, whether the Russian involvement amounts to control of the rebels to the point that we can claim that also turned into an international armed conflict, well, I don't think that we can reach that conclusion, meaning that, and to evoke also the Tadic decision and the Tadic approach, I don't think that Russia was actually exercising overall control over the rebels to the point to then be able to attribute the actions of the rebels to Russia and to say that therefore this NAIAC was indeed an international armed conflict. And then we shouldn't forget that also Crimea has been occupied by Russia for many years now. And again, Marco was correct, I think, in saying that there has been an international armed conflict since then between Russia and Ukraine. Now, what has changed now is that we have a new phase of a conflict that was already an international armed conflict, and this is raising challenges for from an IHL perspective as well as for the application of sanctions and use ad bellum. And now, when we address what is the involvement of other states and whether, so from a use ad bellum perspective, the question is, are states helping Russia or Ukraine violating the ban on the use of force? Does it fall within one of the exceptions provided for in the UN Charter or in customary law? Now, what I will do is actually to look at whether the help and provision of weapons, assistance, money to the two parties to the conflict, so to Russia and Ukraine, whether this makes the states helping them parties to the armed conflict. And so I will start with Belarus, which is providing or it's allowing Russia to use its own territory to conduct the act of aggression. And I decided to put here the UNGA definition of aggression, Article 3F, which basically says that if a state allows another state to use its own territory to commit an act of aggression, in this case against Ukraine, then this in itself is also an act of aggression, or we might say at least it's complicity in aggression if it's not a fully fledged aggression per se. And also in this case, obviously the question is, but does it mean that then Belarus, for committing or helping Russia committing a crime, an aggression against Ukraine, does it mean that then Belarus is party to the international armed conflict? And the other aspect that was mentioned by Marco was, what about all the states, NATO countries, but also other countries that are providing support to Ukraine? So they're providing money, they're providing weapons. Does it make them co-belligerents in the armed conflicts? And there are several positions that we can look at, and I try to summarize them here. So on the one hand, there is the law of neutrality, and there is a view whereby if you violate the law of neutrality that Marco was mentioning before by providing assistance of one of the belligerents, so one of the two parties to the conflict, then you also become a party to the conflict. However, the problem with this, the problem I have with this is that if we accept that violating the laws of neutrality means that you are a party to a conflict, kind of means that we are blurring the lines between jus ad bellum and jus in bello. So we all know that international law is based on this strict division between using force, which has its own rules, and then how do you fight a war? So how do you protect people in war, which is IHL? And these two branches of law are separated. So I don't personally believe that we should use the law of neutrality and jus ad bellum in order to determine if someone is a party to a conflict or not. Now, the problem with this, even if it's the position that I will support, but I do acknowledge that the problem with this and the paradox, especially with regard to Belarus, is that you have a state that, according to the definition provided for by the General Assembly, is committing aggression against another country, but for some reason committing an aggression is not enough to have an international armed conflict between the two countries. Now, this might indeed be a paradox, and we might also claim that at the end of the day it's not very relevant, and right now as long as there are indirect armed confrontations between the two countries. However, it is relevant, for instance, for Ukrainians that are right now in Belarus, or citizens of Belarus that might be in Ukraine, for instance. How do you classify them? Obviously, things change if IHL is applicable between the two countries. Now, in order to solve these issues, some people and some scholars have used the idea of direct connection to the harm of the enemy, meaning that if your support to one of the party to the conflict, so if you're supporting Ukraine and your support provides as a direct connection to the harm that is caused by Ukraine to Russia or the other way around, then in this case you should be co-belligerent. However, if we look at the ICRC commentary, for instance, and the definition of international armed conflicts, we do see that you need use of force which might be unilateral, so even just by one state against another state, and even just of minor importance, like a frontier incident might be enough to trigger an international armed conflict, but you do need use of force. And I tend to agree with the ICRC. It's true that the ICRC is not saying that it's not possible to have an international armed conflict when you don't have direct use of force between two countries. And I think that one of the examples is, for instance, an intervention in another country to fight against the rebels when there is no invitation by the territorial state, which is, for instance, the US-led intervention in Syria against the Islamic State. However, in this case, you do have use of force by the US-led coalition against the territory, the Syrian territory. While in this case, at least to my knowledge, Belarus hasn't used force against Ukraine, and also the states that are providing weapons and money and assistance to Ukraine are not using force against Russia. So clearly the situation is open to debate, but I wanted to raise these challenges that I think are quite peculiar of the situation in Ukraine. Now, and to move on to the second issue, I would like to talk about the involvement of civilians in the conflict, which is also something quite new, maybe the extent of which this is happening. So on the one hand, we have the Ukrainian government that has been providing weapons and has been arming civilians. And I read that recently, but again, I didn't read the law, but I read in the news that apparently now civilians are allowed to use force directly against Russian soldiers, and this obviously raises issues with regard to the protection of civilians and the principle of distinction between civilians and combatants, which is really the cardinal rule under IHL. And then the other challenge that has emerged recently is that the Deputy Prime Minister of Ukraine has announced the creation of a sort of an IT army in order to conduct cyber attacks to counter the Russian invasion. And now this raises all new challenges because it's not just involving civilians in the armed conflict, but also through cyber means, which obviously creates some challenges. So I put here Article 4 of the Third Geneva Convention, where you have the definition of participants in a levée en masse. And I would just like to focus on a few criteria that are relevant. So first of all, you need inhabitants of a non-occupied territory that have to take part in the levée en masse. So technically, this article is going to be applicable to people who are in Ukraine in parts that are not currently controlled by Russia. And this is not, I think, I believe, particularly controversial. However, the thing is that on the approach of the enemy, spontaneously take up arms to resist the invading forces. And now I think that critical here is the fact that the levée en masse needs to be spontaneous. And now, if the government is giving you weapons, or if the government is creating an IHL army, or whatever we might want to call it, I mean, army gives the impression that they are combatants, and I don't want to give that impression, but this IT group of people who are countering through cyber means the invasion by Russia. Now, how spontaneous is that? And the idea is basically, the majoritarian view is that there shouldn't be coercion. So according to the majoritarian view, we can still conclude that they might be part of a levée en masse, because indeed the government is not really forcing them to do it, but they're more invited and encouraged to take up weapons against Russia. However, there is one question here, because it's spontaneously take up arms to resist the invading forces. And I guess in this case, we should also wonder how taking up arms might apply to cyber operations. Like, is holding my phone, and this in particular also for another characteristic which is mentioned later, provided that they carry arms openly. I mean, one thing is if the government gave me a weapon, like a rifle, and then I have to carry my rifle openly. But if I'm part of the cyber side of the levée en masse, I mean, does it mean that if I hold my phone, I give the impression that I might be a potential target, because the enemy might think that I'm a civilian committing a cyber attack through my laptop or phone, or while I was simply calling someone, or playing Wordle or whatever. So clearly this raises challenges when it comes to cyber, on top of the challenges that we already have with regard to whether it's indeed a levée en masse in the first place, when having civilians provided for weapons to fight against Russia. And then, okay, there is also the thing that they shouldn't have time to form themselves into regular army units, and I think that this is pretty straightforward. I don't have any information regarding the organization of these civilians, even if we might, and I'm not sure if the cyber side of it, they might be coordinating probably, but I'm not aware of actually having an organization in IHL terms. And eventually, the last aspect is that they have to respect the laws and customs of war. And now, in this case, I don't think that right now we have sufficient information for that. However, with regard to the cyber attacks, there is, I don't think that they actually reach right now the threshold of attack that is required under IHL to be covered by IHL in any case. And with regard to the levée en masse, the last thing that I would like to raise is with regard to the cyber side of it. The fact is that normally the levée en masse is you have an invading force, an invading army, and then you have the civilians taking up weapons to react to that. However, and so this happens in the territory which is invaded by a foreign country. But now when it comes to cyber attacks, the levée en masse could actually take place against facilities or cyber, I wouldn't say cyber structures, but things that are materially in Russia, meaning that you could have a cyber attack launched from Ukraine that is going to have an impact on Russia, on Russian territory. And now, with regard to the possibility to do a levée en masse against a state which is approaching and attacking another state. And to refer back to what I was saying about Belarus, even if we admit that Belarus is indeed committing an aggression against Ukraine, as long as you don't have an invasion, you don't have also the possibility to have a levée en masse. So it's not possible, even if we admit that that's aggression, this doesn't mean that then the civilians, the cyber part of the civilians taking part in this possible levée en masse have also a right to attack or to target cyber objectives in Belarus. And then I will we finish with humanitarian corridors, so at least we have time for the Q&A. Now, with regard to humanitarian corridors, we have read a lot about it, and it's one of the hot topic of, I might say, of IHL and what's happening right now. However, the question is, how does IHL actually addresses and protects humanitarian corridors, and do we have the notion of humanitarian corridors in the first place under IHL? And I think that the closest notion that we might think of is the one of demilitarized zones, which is regulated by Article 60 of Additional Protocol 1, which basically says that if you have a demilitarized zone, which is a zone the parties agree that is not militarized and should be protected, so you need an agreement between the two parties, in this case, the two parties to the conflict. They agree that this zone is going to be demilitarized, and this means that it is prohibited for the parties to extend their military operations into these zones. So basically, you have zones that are going to be civilian in nature, and no military operations can take place within these zones. Now, there are some conditions to that, and if these conditions are not met, and I go back to the conditions, but in case these conditions are not met or are infringed, what happens is that the demilitarized zone loses its special protection. It maintains protections that are established for by other articles of IHL and other IHL rules, for instance, the special protection of hospitals or healthcare facilities, but as such, they are not going to be considered the militarized zone anymore. And the conditions are that, first of all the combatants have been evacuated. No hostile use shall be made of military installations, because obviously you can evacuate all the combatants, but what if you have a military base in a demilitarized zone? Then in this case, you should stop using it for military purposes. There shouldn't be acts of hostilities inside the zones, and also no activity linked to the military effort should continue. So obviously, it doesn't take much fantasy to understand that these conditions have not been met in the case of the humanitarian corridors, which means that the humanitarian corridors, as a consequence, cease to be protected, basically. However, I would also invite you to distinguish between the humanitarian zones and the demilitarized zones that I was mentioning before, and the security zones, which are the safe havens that we have seen, for instance, during the war in Bosnia and Herzegovina, and unfortunately they have become infamous because of some horrible things that happened there. But anyway, just to invite you to reflect that these are completely different instances. And as to whether humanitarian corridors might be qualified as demilitarized zones, the definition provided for by OCHA with regard to humanitarian corridors is that they are specific rules agreed upon by all parties to the conflict to allow the safe passage of humanitarian goods and/or people. So I think that this fits well with the definition provided for by Article 60, as I was mentioning before. And one last thing that I would like to mention about humanitarian corridors is the problem of how to ensure the protection of these humanitarian corridors, how to ensure that they remain humanitarian and they don't lose the special protection which is provided for by IHL. And in this case, I think it's worth remembering the ICRC customary law study, which expressly says that practice indicates that the best way to protect these humanitarian corridors is to have international supervision or peacekeeping forces or police personnel, but this obviously raises the issue as to whether they do remain militarized if you introduce peacekeeping forces that obviously wouldn't be parties to the conflict, so technically they wouldn't raise an issue, but still it would risk to actually militarize what is actually supposed to not be militarized. I will stop here.
Perfect.
Okay, and we can stop sharing. Okay.
Okay.
I think it's already. Okay.
All right. Yes. I'll go back to the first one. Okay, we have 4 questions online, and I'm sure we will have some questions also from in the room. So what I think I'll do, how should we do this? We could alternate, that may, or the highest bidder? No, let's alternate. Why don't we start with a question that came in online. This is for Professor Duan. Regarding the legal basis of unilateral sanctions, could they be justified as a measure of collective self-defense? I'm not sure if the question pertains to the current crisis or more generally, but maybe you could address it both ways.
Can we probably go for the sake of time, as far as we have a limited time, probably we shall go through all the questions all together and then we all.
Want to do it that way? Okay. We have a question for Professor Roschini. If the questioner understands correctly his proposition, it suggests that the jus ad bellum ceases to apply when an armed conflict erupts. I find it hard to believe that any justification, even if legal, back in 2014, is enough to satisfy the legality of Russia's actions in 2022. That's the second question. And let's take one question from in the room. If somebody, oh boy. Okay, start on the left. Yes, please.
Yes, so my question is for you. So you.
Oh, and speak loud because I think these are the microphones. Yeah, speak loud because they're far away.
Just at the end, you said that you were talking about the development of this cyber defense that could attack in Russia. And you said that it would probably not fill the level of mass criteria and then not allow the civilians to participate in the hostilities. But for the way I understand the article of Levermas, it's more to know if they're going to have prisoner of war status. So I was wondering, how can we really use this article to say that civilians are allowed and not allowed? Because for me, I don't see IHL as giving the right to participate. It's more what's going to be your status and your protection in this situation.
Okay, so we have one question for each participant. Why don't we start with Professor Duan? And go in the order of the questions.
I believe that's a very interesting question because it raises, I believe, the issues which have been touched upon all the speakers, and the question which is potentially dangerous due to the possibility of various interpretations. Theoretically, if we speak about the interpretation of the ICRC of the notion of collective self-defense and the means which can be taken in the course of self-defense, so the list of means is not limited, besides the limitations imposed by international humanitarian law when we speak about the non-selectiveness and overseeding damage and so forth. So therefore, theoretically, when we speak about the collective self-defense mechanism, different means may be used. The point, however, which comes upon my mind, that we shall have a case of collective self-defense. That basically means that we shall speak about the belligerent parties of the conflict. Then it comes to the point, if in the situation which we are discussing today, we qualify it as a means of collective self-defense, we shall then say, A, that we have a conflict among everyone who is applying sanctions in that specific case. And I believe that's a really bad development of the situation, which expands the conflict all around the world. Point number 2, when one speaks about the countermeasures, again, and I will elaborate here a little bit, there is a notion of collective countermeasures, which provides for the possibility to react for states which are not directly affected by the very fact of the violation. If I'm not mistaken, Article 42 of the draft articles on responsibility of states. And in that case, there could be a possibility to react. But again, in accordance with all the standards, proportionality, necessity, and no fundamental human rights can be violated in that case.
Just as a sub-question to this, do you know, or does anybody know if any of the sanctioning countries has claimed self-defense in relation to the sanctions? I don't think so.
Never.
So,
No, I mean, the question was whether sanctions can be imposed in the course of collective self-defense.
Yes, I'm thinking of this particular situation now.
No.
I don't think anybody has.
No.
Okay, thank you. Professor Rossini.
Thank you. I'll be very quick. No, that's not what I meant, and don't believe that's what I said. I'm not claiming at all that Russia's invasion in 2022 is lawful because the use contra bellum does not apply to it. What I'm saying is that once a use of force is a continuing act, in order to establish who's the aggressor and who's the victim, you have to look at the first act. And for me, the first act occurred in 2014. So Russia's invasion is unlawful, not only and not mainly because it's unlawful in 2022, but because it was already unlawful in 2014. And the 2022 crisis is the continuation of that situation. So if there had been a significant interruption of the use of force between 2014 and 2022, you could have claimed that it's two separate uses of force that require separate justifications. But if we again assume, as a matter of law, I appreciate that Russia itself is claiming that they need to provide the right justification. But as a matter of law, if the use of force is continuing, as the occupation is continuing, as the direct and indirect support for the separatists is continuing, then again, 22 is not the first episode. It is again an element of a continuing act. And again, I'm not saying that the use of bellum is irrelevant now, but it is relevant not to establish who the aggressor and who the victim is. It is relevant to assess the legality, meaning the necessity and the proportionality of the defensive reaction, which is an exercise that must be done not just for the first shot, but for the whole duration of the reaction.
Okay, thank you very much. And Karen?
Thank you. I didn't mean to say that if you're a civilian in a levée en masse, then you have the right or the combatant privilege of taking up weapons to fight against the government. My point was really that this is not a bookcase of levée en masse where you really have individuals spontaneously taking up weapons as Russia is approaching a particular town or city, but it's actually the government kind of encouraging these people, and therefore, due to the scale and the fact that, okay, it's not forced, but it's invited and strongly encouraged, apparently, what does it mean for the civilian nature of the civilian population when you are provided for a rifle? I don't think that having a rifle from your government makes you necessarily a civilian taking direct participation in hostilities just because you accept that weapon that the government is giving you, or just because you accept to be party to the cyber civilian side of the war, let's say, but again, civilian with blurring lines. So this does raise challenges in terms of, I mean, it's almost if you go from taking that participation in hostility to almost having a continuous combat function. I would imagine, and I'm not an IT expert, but I would imagine that it takes some time to prepare a cyber attack. And if that attack indeed qualifies as attack under IHL, then during the time when you are preparing this attack and you're coding and everything, you might qualify as a legitimate target. And this, obviously, the Leviamas article per se refers to the prisoner of war status, but it does raise all these different challenges and connections with other rules protecting specifically civilians, but here really the lines are blurring.
Okay, thank you. And I think we'll do another mixture of questions, and this will probably be all we have time for which we apologize to those we don't get to. But one of them reminds me back when I was a journalist and people would ask these 5-minute questions. But I'm going to cut this one. I was going to cut this one down a little bit. This is for Professor Roschini. Starting with your argument that the conflict actually began in 2014. It's a good question. The idea of the questioner is that on this basis, the current invasion would enlarge the scope of, would seem to enlarge the scope of necessity and proportionality of the pre-existing right to self-defense. That this would mean that defensive responses to subsequent attacks must be assessed under both jus contra bellum and jus in bello. If this is your position, and if it is your position, what nexus is required between the original act of aggression and subsequent uses of force to consider them to be part of the same ongoing armed attack? Or do you rather consider that all subsequent uses of force during the armed conflict should only be assessed under jus in bello? I'll take one more from the room, and I think, I don't know who was first to raise the hand, but okay.
Correct. Had several questions actually for Andy, but I'll try to be as simple as possible. And it's a bit of a follow-up question concerning like the centers of people that civilians that take part or call upon. Because I mean, we talked about the possibility of being identified like as part of the armed forces to some extent, and then according to the principle of distinction, the fact of carrying out an arms that can be like also as weapon can be like evidence of that. But I mean, if it's not recognized as a combatant status, if those people are not recognized as being combatants, then they are civilians, and if they directly participate to cities, they can be targeted. But in that situation, would carrying out a phone being like enough to be considered as directly participating? Because I mean, this is a very unnatural question for dummies as for cyber attacks, because I don't know, I mean, to what extent an hostile act in cyber law can be, to what extent a cyber operation can be considered a hostile act. And in general, this is like a broader question. I guess there's no provision in IHL 52, but to what extent is it recommendable for a government to ask for the civilians to, give help into military operations? Because I mean, maybe it's more recommendable for a state to rely on the armed forces only, because otherwise a state would also carry out a sort of dissemination activities, which is way more broader and widespread than just training its own armed forces. So yeah, general opinion on that. And I also have another question for Special Rapporteur.
I don't know if we have time for a third one, but we'd certainly appreciate if there's time later afterwards.
Yeah.
That'd be great. Okay, Professor Roschini.
Thank you. That's an excellent question. I said that I would be controversial by saying what I said, and it's a question that is basically about when a use of force basically terminates. There is, I mean, in using bello, there is a debate about, when the armed conflict starts and when it terminates, but I'm not aware of a similar debate in the use of bellum area, so that's a good topic for research. When does a use of force actually end? And and I haven't thought about that very much myself, but I would say it's a factual assessment. So if we assume again that occupation is a use of force, if we assume that sending regular and irregular or even arms to insurgents is a use of force, right? Which I think is relatively uncontroversial. We could debate whether it is an armed attack, but perhaps less whether it is a use of force. So if so, the question, when does that use of force terminate, is when there is evidence that occupation is over, and when there is evidence that support for the insurgents is also over for a reasonable amount of time. I give you an example. This argument that the jus ad bellum issue was not relevant because there was already an armed conflict between the concerned states was used by Israel, for instance, in 1981 to justify the bombing of the Osirak nuclear reactor. The claim was that there was already a state of war between Israel and Iraq, and therefore there was no need to further justify the bombing of the nuclear reactor. Although Israel does not use the argument exactly in that sense, it's more as a context of the necessity in preemptive self-defense. That's a justification itself. But anyways. But in that case, I wouldn't say that the argument was convincing. Why? Because there had been no shot fire between Israel and Iraq since at least 1973, the Yom Kippur War. So I wouldn't say that in that case, the 1981 episode is the continuation of a state of war that existed since 1948 between the two states. Operation Iraqi Freedom, you certainly couldn't claim that Operation Iraqi Freedom in 2003 was the continuation of the use of force that occurred in 1991, because that use of force, that armed attack by Iraq against Kuwait had been repelled in 1991, and obviously the self-defense of the victim had been over since then. So as you see, I think that these situations are different from the situation of Ukraine, where the initial use of force in 2014 has never actually stopped. The occupation is still there, and the supply of weapons and the exchange of fire has been. There have been ceasefires, the Minsk agreements, but A, they have not been complied. B, there are ceasefires, and therefore they haven't extinguished any right of self-defense by Ukraine.
Okay, thank you, and Dr. Redeli.
Thank you. So, I do agree on the fact that, for instance, carrying a phone would be hard to qualify as direct participation in hostilities simply because I'm going around with my phone in my hand. I mean, everybody in Geneva will be taking direct participation in hostilities potentially. What's problematic and what's really challenging when it comes to cyber and IHL is the fact that weapons are not the traditional weapons that we are used to think about, and adapting the traditional IHL rules that were developed when phones weren't even a thing, like cell phones, to the situation right now, it is indeed challenging. And obviously, I mean, the government then has to make its own choices and evaluations in terms of how much do you want to involve the civilian population. But in any case, in this assessment, there should be taken into consideration the fact that by involving the civilian population, the risk is that you expose the civilian population to possible dangers, even if the civilians in that specific case don't qualify as taking their participation in hostilities or levée en masse. you still kind of create the perception that any civilian potentially might have a weapon and might fire against you, or might be a potential person taking part or organizing a cyber attack. And it's true that, I mean, whether a cyber attack amounts to an attack under IHL, it's controversial, but the majoritarian view is that if it has consequences in the real world, then it should, like destroying something, then it should be considered as an armed attack under IHL as well. And so it kind of creates the suspicion that you want to avoid, for instance, by prohibiting perfidy, which is really like, you shouldn't create the impression that someone wearing an ICRC vest might actually be someone just pretending to be an ICRC staff and might actually be someone who is going to attack you. And it's exactly to avoid these things that you want to keep it very strict, the distinction between civilians and combatants, and obviously governments should take that into consideration when deciding to provide weapons to the civilian population.
Okay, well, I think we better end here. At least some of us have to scram to another meeting. But those of you who are able to stay, perhaps even online, can continue. And I hope there's the possibility for that because there are some really rich discussions to continue having about this. I don't know when this particular conflict is going to end, but if it doesn't end soon, maybe we'll have round 2 of this one day soon. In any case, thank you all for participating online and in person, and thank you again to the Geneva Academy for the invitation and the organization of all of this. And thank you to the other participants.
Thank you.